Hi everyone, I'm Janet Allen with Republic Title, and today I'm here with Scott Rooker. He is residential counsel here at Republic Title, and today we're going to be talking about home surveillance legal issues and the implications that you, real estate agents, have and responsibilities that you have when you are listing property that has surveillance in it, and when as a buyer's agent, when you are selling property that has home surveillance. So let's talk listing agents and sellers first, Scott.
Sure.
All right, so what do these listing agents need to be doing, saying, what do they need to know?
So you're a listing agent, you're going on to your appointment for a potential seller. The questions you want to ask are you the owner? Are you married? Are you a foreign person? And where are the cameras? Are they audio? Are they video? You really want to understand where these are because they have serious legal implications. From a video perspective, typically video is okay. In the living room, in the kitchen, outdoor, indoor, that's typically fine. Where you cannot put a camera though, or video, is where a person has a reasonable expectation of privacy. So for instance, the bathroom or changing rooms, no video.
Makes sense to me. What about audio?
From an audio perspective, it's a little bit different. From an audio, Texas is a one-party consent rule, meaning if I'm a party to the conversation, I can covertly record that conversation, and typically that's going to be okay. Where sellers get into trouble is when they have the audio turned on during a showing, and they're not at the property, they're not involved in the conversation, and they're at the coffee shop or they're down the street, but they're listening and watching me as a buyer go through the house. That is likely a real potential issue for an illegal wiretap, which is, in Texas, is a second-degree felony. Second-degree felony. It's on the same lines of arson, burglary, solicitation of a minor.
Wow.
So it's very serious. From a civil perspective, it's a lot of money. It's $10,000 worth of damage. It's punitive damages. It's attorney's fees. It's court costs. So it can be very, very costly on a civil side. So you have civil liability and criminal liability. Even though it's their own house, they cannot illegally record somebody unless they're a party to that conversation, or if they have prior written consent.
Okay, so speaking of prior written consent, what does a listing agent, how do they disclose, do they need to disclose, say, in the MLS that it's a smart home, or what would be the best course for them to take in notifying people?
Sure. First, just from the beginning, is to have the conversation with your seller to say you're not going to turn on any audio during the length of this listing. Now, they may agree to that in writing, which is great, but are they going to obey and actually do it? That's another question. At least you have that piece of paper. Also, on MLS, that's a good start to let others know that there's home surveillance here. But you can go a step further and actually obtain written consent from a potential buyer, not the buyer's agent, but a potential buyer, that this house may be under surveillance and audio and video is being recorded. So if you have written consent, that's great. Even a sign in the front yard that says this property may be under surveillance, audio and video recording, it's good. Will it hold up in the court? Maybe you can find out.
Maybe yes, maybe no.
Yes.
You never know. With that being said, there is a lot on this topic that we have yet to cover. And next up, we'll be talking about buyers and buyer's agents. So we'll see you in the next video.